Welcome to As Long as the River Flows, a Keepers of the Water podcast. Episode 21 is the conclusion of a two-part series on the protection of treaty with Margo Auger from Treaty 8. In Canada, treaty rights are constitutionally protected under Section 35 of the Constitution Act 1982, recognizing and affirming the rights of Indigenous peoples. This protection ensures that treaties, including modern treaties, are given the force of law. Join Keepers of the Water as we pick up with Margo Auger of Treaty 8 and continue to discuss the protection of these treaties. Margo Auger is a Nehiyaw Iskew from Bigstone, Cree Nation. She is a wife and mother to 3 beautiful children and Kokum to 1 handsome grandson. She is a working professional with over 26 years of experience. Her background is in First Nations governance and leadership, executive management, chief administration leadership, and as a certified use planner and project manager. She has worked in municipal government and the energy sector with oil sands companies as managing growth consultant for the Alberta government and Treaty 8 First Nations.
Some of the case law, I'm not going to get into them, but the Calder versus Attorney General, that's BC, recognizes Aboriginal title, 1973. Now you start to see what happened. Finally, we were allowed to hire a lawyer in the 60s, late 60s, it was about. I wasn't even thought of then. Guerin versus the Queen, recognized pre-existing Aboriginal rights both on and off reserve. Because you got to remember too, they couldn't kill us off, so we're going to legislate them to death. We'll legislate them on the reserves. Keep them on the reserves. Have you ever wondered why we say we're supposed to be tax-free? Does anybody know why we're supposed to be tax-free? Think about that. I'll tell you why later. R versus Sparrow recognizes, Regina versus Sparrow recognizes Aboriginal rights. The existing Aboriginal treaty rights of the Aboriginal peoples of Canada, it says. We are not Canada's Aboriginals. Delgamuc versus Gizde confirms Aboriginal title, 1997. I'm not going to get into them. I just want to show that how many times do we have to take your Canadian government to court, your provincial governments to court to understand, to see we own the land. Your own case law affirms that. Your own royal proclamation affirms that. Haida versus BC, again, that was another title one. Forestry. Taku River versus BC, the duties of consultation accommodation with respect to government decision. This is cool, right? This is starting to come out. Click. Duty to consult. Mikisew First Nation versus Canada. That is a Treaty 8 nation. What's so interesting about this? What happened? I used to work for the government of Alberta. And so I learned a lot there. I had some colleagues. But what happened? I didn't realize I was my boss at the time that I was in government of Alberta happened to be one of the pre-writers of this consultation policy, First Nations consultation policy established at Alberta government. First Nation. Just because they called it First Nation doesn't mean it's ours. Canada does that too. So what they do, they didn't know, well, how do we know which Indians to consult with? So they went back to the nations and they said, hey, send us your maps, your traditional land use territories, so we know who. Some of the nations were pretty smart. They submitted a whole map of Canada, south of the United States, because they knew what was going on, right? But they could also they could also follow their ancestry. Some of the nations should have, at the very, very minimum, used their treaty boundaries, right? At the very minimum. R versus Marshall confirms Aboriginal interests are burden of the crowns. If you hear me speak a little different as well, I think in Cree, so when I present, you're going to see my English is not the greatest. Rio Tinto versus BC Mines, 2010. It confirmed the Haida test of when the duty to consult arises. So we're telling you guys, we keep winning. You have to consult with us because we're the landowners. How many times do we have to go to court? Kokum Nation versus BC. And even though these things took place in BC, it doesn't matter with these provinces, right? Even though that's the court structure that's set up today. Doesn't matter. Those territories are still there intact. If it wasn't, we wouldn't be here, right? We wouldn't be sharing the lands. This is another cool one. This happened just 2 years ago. Not too many people are familiar with this one. Fort McKay, which is another Treaty 8 nation, versus Prosper Energy versus Alberta Energy Regulator, 2020. Just 2 years ago. Just about 3 now. This was a situation when I happened to be working at Alberta government when it was our ministry. I was working for Indigenous Relations. And the ministry that I was working for, in fact, the department I was working for, was actually in conversations and discussions for over 19 years at the time with Fort McKay. And Fort McKay did a land use plan and said, you know what? You know Fort McKay is in one of the nations which are in what's known as northeast of Alberta today. It's in Treaty 8 territory. It's where all the oil sands activities taking place. They had one area of land called Moose Lake, and they wanted to protect that. It's the only one that's left intact. I can't say that it's totally pristine because there are no boundaries in air when it comes to contamination and cumulative effects, right? So what happened? Well, Alberta government decided, Alberta Energy Regulator, even though they had a buffer on that lake that said there'll be no development within this buffer of this lake. Alberta government went ahead and approved a permit to prosper within that buffer. Fort McKay said, I got no choice. Even though we've been working with you guys for how many years, we did a land use plan. It's ours. It's under our law. You went ahead and approved it. Let's go to court. And they won. They won. Why did they win? And look at this is what's important. But I'm going to tell you, like, this is why I don't sleep much at night in my job, right? Because it's so gross what we have to live with as Indians. The honor of the crown extends beyond the duty to consult. You know what that means? It means it's not just a matter of, hey, let's talk about this. You know, we're going to have this application, and we're gonna allow it to happen, and maybe you can give your nation some, I don't know, labor jobs or whatever, right? let's give you guys some monies for your treaty days, right? And I was going to call that consultation. It's beyond that. That's what they said. It's beyond that. It's not just a matter of consultation. You have to act in a manner that advances the intended purpose of Treaty Number 8. Treaty Number 8. I'm talking about that actual treaty territory, right? We were there first. That still exists. That agreement is still live. And regulatory agencies such as Alberta Energy Regulatories or Regulator, whatever the name is obligated to consider impacts on the inherent and treaty rights. Case Law 2020. What did Indigenous Relations say? What did Minister Savage say? What did Forestry say? What did Alberta Environment say? Oh, that's only, you know what that means there, Treaty 8? It means that it's only within the Moose Lake. That's where we have to abide. Site-specific. Don't be dumb. We have people now who know and understand and can comprehend law. We have our own lawyers. We know what that means. And have you ever forgotten? We have an ability to think now. You know, you assimilate us, you colonized us, we're speaking your language, we're reading your kinds of curriculum. But I have my own understanding, and you can't take that away from me. So no, it's not site-specific. It's all Treaty Number 8, regardless of your boundaries, your provincial boundaries. And it's important that many of the nations, especially the nations that are now within Alberta, know and understand that particular case because it's to your advantage too. Blueberry First Nation is another nation. It's another case where there was, over the years, the BC government, so it's a Treaty 8 nation. There was a number of, the industry kept developing, and BC government kept approving. And it got to the point where it was total treaty infringement. They had to go to court, and they won. Cumulative effects. We talk about cumulative effects. What are we talking about? You heard me say this word a little bit here earlier when there was no boundary in air, no boundary when it comes to contamination, pollution, waters, right? They lost a lot of their ability to live the life of treaty, the freedom of treaty. We're supposed to be able to live our lives as though we never entered into treaty. And what does that mean? What did they say? Well, BC government wouldn't take it to Supreme Court. They said, okay, all right, we admit. Why didn't they take it to Supreme Court? Any lawyers here think? Why did they not take that to Supreme Court? Come on. Why do you think? Yeah, well, it's because they lost it at the provincial level, and you take it to Supreme Court, and Supreme Court has to take a look at that and say, holy crap, that's got to apply to all the provinces, right? Isn't that how the Canadian Constitution works, the Canadian process, right? The delegated authority, Section 91, 91, 92. It's no wonder why they're trying to do an Alberta Sovereignty Act, right? Makkway sovereignty. Makkway means nothing. Southland versus Canada is another case that just recently transpired last year. This is also very significant, even though it's within the pre-Confederation treaty, so the treaties that occurred before there was this Dominion of Canada. There was a flooding that took place in a reserve, and literally that nation lost its land and territory and was pushed out. They went to court, they won, and they found, and they were successful because, they created a dam, and it really took away the livelihood of this nation, and they won. Equitable compensation taken for Indigenous land. What does that mean? So you see, it's still happening. We're still winning, but nope. Here's treaties 1 to 11, treaty areas. I'm not going to go into a lot of detail, but I just want to show you. Treaties 1 to 11, treaty 8. So this is an international treaty. They're different. Today, you hear the word Indigenous. Every time this governments change, they give us a new name. Indigenous means they're going to loop in all the treaty Indians, all the First Nations, the First Peoples, with the Inuits, with the Métis, put them all in one big basket and treat them all the same. And then this way we can sort through the monies piece and see how we can continue colonizing and controlling them. The Robinson-Huron treaties, the William treaties, those are all the pre-Confederation treaties. That case I talked about took place here in this region. Treaties 1 to 7 happened within, treaties 1 to 6 actually happened within 6 years. Really, really fast. Boom, 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 boom. Year after year after year. Does anybody know why? And if you've heard me, does anybody know why it took 22 years before Treaty 7 and Treaty 8 was entered into? Does anybody know why? What is it about Treaty 8 people? What is it about Treaty 8 that makes it so special and different? It's not just because of the beautiful people in it. Resources. Gold, right? Klondike Rush. They were after. They knew what was in the ground. But you got to go back to our treaty because our ancestors knew too. And they said, we are only entering treaty into a depth of a plow. We did not give away our natural resources. Mineral rights retained. How many of you own land in a city or a town? You know, it comes with you have a land title. How many own land title? Have you ever read your land title? It says, I'm going to pretend, Margo Auger, plan, block, lot, title owner, accepting their oath, all mines and minerals. Why do you think it says that? Right? Oh, by the way, when I go back to that, treaties 1 to 11, that land base, you know how big that is? Of what encompasses of what Canada thinks it owns today? That's 65% of the land. 65%. So we're in school in social studies, we're taught that the 7-Year War took place, but this is all you have to memorize. And that is how come we have a British monarchy. That's what you're taught in social studies. But you know what we're teaching our people, teaching Canadians and Albertans today? That is our land. The Royal Proclamation affirms that is our land. We didn't cede the people. They have Aboriginal title to the territory lands. 1871, why is that significant there as well? You see how there's this little square here is because one of the treaty territories at the time, 1, 2, and 3, one of them wouldn't enter into treaty right away because they knew what was going on. They waited, and then and that was about the time this was taking place. But 1871 is also significant because that's the time when there was this Dominion of Lands Surveys Act. I forget what it's called, but that's when they started to come and survey the land. That's when they started and created that act. And all of a sudden you see Great Britain has a little land. Now all of a sudden there's like a Dominion of Canada. All of a sudden. So you start to see legislation. You're wondering, we're talking to our own students, our own people, like, where were our ancestors? Why didn't they fight? Where were our ancestors? We talked about this. Today, look at that. They refer to this 0.2% Indigenous lands. Reserves. That is not our land. It's the territories. Remember that 65% I mentioned? But you know what's going on today? Baby Trudeau is implementing his dad's white paper. And along with the provinces, you talk about the Sovereignty Act, they're all after our lands. They're trying to make all of those little green little dots into municipalities. That's what they're doing. Let's go back to this. Remember when I asked, why are we not supposed to be paying taxes? Did the Queen pay taxes her whole time? She's sovereign. Does the monarchy pay taxes? Right? Sovereign to sovereign. That's why it's in our treaty. We're not supposed to pay taxes. Doesn't matter if you put me on a reserve. A lot of us have been paying land taxes, property taxes, all kinds of sale taxes. The irony, right? We've shared the land with you and you're making us pay for it, and then you're making us pay taxes on top of it, right? Oh, and by the way, we're not going to let you manage it as well. There was a question here a little earlier today about why is Treaty 8 very positional when it comes to the Assembly of First Nations, AFN. AFN was an advocacy organization, administrative organization that was supposed to support and advocate, but it was supposed to support and advocate from the direction of the sovereign nation leaders. And what happened? Well, baby Trudeau, in his devolution of treaties process, his rights and recognition framework process, what did he do? They signed an MOU agreement with the Assembly of First Nations, and what that MOU agreement said basically is that you are our one-stop shop, distinction-based process. We will co-develop everything with you. We're going to co-develop your health laws, your language laws, your land laws. There's like 34 things that they're co-developing without us. Remember? Sovereign nations. We didn't delegate our authority, our decision-making, our jurisdiction to an organization that doesn't come and meet with us. And what are you doing, AFN? The work that you're doing at that level nationally with Canada is taking away the jurisdiction and authority from the very, very First Nations that created that organization. That's why things are so gross, is because your Canadian government keeps creating process after process after process. See, you notice I didn't really refer to any parties because it doesn't matter what parties are in there. It's the system of governance. I spoke about Section 9192. That's, remember this Alberta Sovereignty Within a Canada Act? What happens to Section 9192 if you're going to decide, those are delegated, constitutionally delegated powers and authority that we're giving you, Alberta, says Canada. All right, oh my God, we're not even anywhere near there. The AFN is sitting at that level with Canada, and our nations are over here. This is where we're supposed to be. When we heard Sharon talk about the governance, our natural laws, you see on the top there, Creator, she talked about ceremony. That's the relationship, ceremony. We manage ourselves. We talk about hunting, fishing, trapping, gathering. You hear they're called treaty rights, but it's actually our inherent rights. That was that sharing of lands. Livelihood for livelihood. We're not supposed to alter the way of life. It was supposed to be, we're going to coexist, we're going to co-live as though we never entered treaty. That was the agreement. That's what she's saying over here. Under the regulations, they decided what treaty means. They decided what treaty rights are. They decided what the impacts are to the treaty rights, and they came up with their own measurement without the treaty people. And then what did they do? They created this Aboriginal Consultation Office. They created all these policies, but then they took hunting, fishing, trapping, and gathering, and they put them under their regulations and defined them as recreation. My way of life is not recreation. That's the problem. This is how they manage our territory. Again, I'm not going to go into this. This is Alberta. They call this thing Greenland, Crown Land, public lands, and they're creating all these task force committees. They're managing and planning our lands without us, with the municipalities, with industry, without us. There are no such thing as Crown lands. It's treaty territory land. Treaty 8 encompasses the majority of Alberta and goes right into the mountains, Jasper, and right to Lake Louise within Alberta. And then it goes into Northwest Territories, Saskatchewan, and BC. So they're making all these laws, regulations, etc., and they're doing it without us. That's the problem. We're talking about water. They're doing this without us. That's not what we agreed on. We didn't agree for you to manage us. You can't manage the animals. This is what they do. This is Canada. Remember that treaty relationship? We're supposed to coexist. What did the highest level of the province here say, the courts say, under Fort McKay? You have to work with the treaty nations. Treaty number 8, it has to be for the intended purpose of treaty number 8. Does that look like that's what they're doing? Bill C-69, see, they just ignored the treaty relationship. The Canadian Navigable Waters Act, Indian Act. Do you think we would have entered treaties to share the land if we knew they were going to control, manage, and dictate who we are? Nope, that was never the purpose. Provincially, they do this too. This particular government implemented a bunch of Red Tape Reduction Implementation Act. Do you want to know what the red tape reduction is? The Indians are the red tape. Everything and anything that says the duty to consult. Take it out, take it out, take it out. Red tape, they're red tape. Natural Resources Transfer Act, illegal. It is legal. It just about fell. Bill 1, Alberta Sovereignty Act. Did you know when you look in there, they defined us? Aboriginal peoples of Canada? Get us out of your act. I'm not part of Alberta. And I'm not part of Canada. I'm not the Aboriginal. Am I the Aboriginal peoples? Because you're calling me Indigenous. But in the U.S., they're calling us creatures. What are we, right? We're the first peoples. We're the Nehiyaw. That was my presentation really fast. I didn't get into it. I'm not going to show, the Treaty 8 nations have been working united, and they are actually working collectively on our lands and territories. There's a lot of education and awareness going on out there. And we're trying to protect what's rightfully ours, our lands, our waters, our resources, and our territory. We can create this governance system similar to what Canada has done, what Alberta government has done. We can assert that. We'll entertain your constitutions. And I don't mean like entering as in I'm going to abide by your Canadian Constitution. We have our own. We have our natural laws. So we know who we are. And that's the situation, right? But when you think about this, what can you do? What can you do at your nation? What can you do as a person? For those of us who have inherent and treaty rights, we have an inherent responsibility. Stewards of the land, we talked about that. Stewards of the water, we have a collective and a nation responsibility as well. We know what that's supposed to be, right? What can we all do? If we all knew the process, wouldn't we be able to just coexist in a little bit more peace? If they would just quit imposing on our jurisdiction and authority, our sovereign nation's jurisdiction and authority? That sovereignty, we already entered into a relationship. We are already sovereign. We don't need Alberta to say, you're sovereign under our Sovereignty Act, right? So yeah, as a law development, I will admit that. I will say that. We are working with our elders to teach and educate what those natural laws are still today. They're in our languages. So for those of us who don't speak or understand our languages, it's a different interpretation. It's a different understanding. When I translate Cree into English, it totally takes the meaning away.
Thank you for listening. That was Margo Auger of Treaty 8. If you would like to donate to the cause or find out more about Keepers of the Water, visit our website at keepersofthewater.ca. Make sure you go to the Keepers of the Water YouTube channel and Facebook page and like and subscribe for more content. And don't forget to download and subscribe to the podcast to be the first to hear new episodes. Miigwech.